G'day and welcome to the Patently Strategic Podcast, where we discuss all things at the intersection of business, technology, and patents. This podcast is a monthly discussion among experts in the field of patenting. It is for inventors, founders, and IP professionals alike, established or aspiring. And in this month's episode, we're taking a journey across the pond with a discussion on European patent practice. This episode is part 2 of a series we're doing on international patenting and follows Ashley's exceptional travel guide to foreign protection from earlier this season. To help navigate the very complicated European landscape, we reached out to good friend of Aurora's, Dr. Will Doherty of Albright IP. Albright is one of our go-to foreign associates for helping our clients obtain the best possible European IP rights across all the key markets. And we're so glad we did. In this episode, Will puts on an absolute masterclass on European patent practice. For anyone less familiar with international patenting, I highly recommend you check out Ashley's episode. But as a brief on-ramp, in a globalized economy, it's essential to understand that patents are still nationalized documents. For example, a U.S. patent only grants the right to exclude others from making, using, selling, and importing the claimed invention within the United States. It has no bearing on activities in Europe, Canada, Mexico, China, or anywhere else in the world. To restrict activities there, you'll typically need a patent granted in each relevant country. This can boil down to filing and prosecution on a per-country basis. However, those seeking protection in Europe do have some additional options for a single application granting protection in multiple nations. 39 contracting nations of the European Patent Convention, a separate treaty more inclusive than EU membership, have organized a unified European Patent Office, for short the EPO. Instead of applying directly to the national patent offices, you may file a single application with the EPO. That office then examines the case, and upon its allowance of the claims, you may then pay an additional validation fee for each member country of your choosing, plus any further translation costs, to obtain a proper national patent in each of those countries. And as the panel will discuss, there's also more recently an additional or alternative form of patent protection available in Europe under the unitary patent, where 18 signatory countries have agreed to have one forum for patent proceedings, resulting in one decision that is enforceable across all 18 countries. Given many strategic factors, understanding your options is key to securing robust international protection for your inventions. You'll quickly see why we asked Will to guest host this episode and helping us unpack everything you need to know about European patent practice. Beyond being a great teacher with a sharp sense of classic British humor, Will is an experienced, chartered British patent attorney, European patent attorney, and IP litigator. As a patents director at Albright, he prepares, files, and prosecutes patents with great success in a wide range of technical sectors globally, in addition to handling patent infringement matters. Will is a member of and regulated by IPReg, the independent professional regulatory body in the UK for patent and trademark attorneys. He's also a long-standing member of the Chartered Institute of Patent Attorneys in the UK and the European Patent Institute. Will's academic background is in chemistry with a doctorate in physical and theoretical chemistry. When delving into any new topic, I'm constantly ribbed a little for trying to take everything back to the Big Bang, but I do think the approach is invaluable for building context. We did this with Professor Mossoff in our Why Patents Exist episode, which primarily focuses on the genesis of the U.S. system, but Will does this beautifully for today's story on the other side of the Atlantic. The conversation is highly practical and instructive, but Will kicks it all off by delving into the rich tapestry of European history and how nationalism, warfare, and subsequent socio-political shifts heavily influenced the creation and adaptation of legal systems across Europe. Tracing all the way back to the Napoleonic era, Will provides a highly entertaining, fast-paced historical framework for understanding the continent's diverse legal traditions, which manifest in significant strategy-impacting ways even today. Along the way, Will and the panel discuss European patent process, EPO participating countries, key players in the system and how it all compares to the USPTO and PCT processes, strategic considerations around filing in individual countries versus using the EPO, translation implications, cost considerations, fee timelines, filing timeline implications, market alignment, and rights enforcement, interplay with newer unitary patents and the Unitary Patent Court, and key practitioner takeaways, including some insightful claim drafting tips for medical type applications, which are viewed very differently in Europe than in the US. Will is joined today by our always exceptional group of IP experts, including Dr. Ashley Sloat, President and Director of Patent Strategy at Aurora, Dr. David Jackrell, President of Jackrell Consulting, Kristen Hansen, Patent Strategy Specialist at Aurora, Albert Du, Patent Strategist at Aurora, and Dr. Tiffany Miller, Patent Strategist at Aurora. Now, before jumping in with the panel, We'd like to take you to the next installment of the Mossoff Minute, a monthly segment that builds on our Patent Wars episode and features short conversations with Professor Adam Mossoff, providing updates and quick takes on movements in patent reform, significant court rulings, innovation policy happenings, and occasional Star Wars references. We'd like to congratulate Adam this month for being asked to join the United States Patent and Trademark Office as a senior advisor, where he'll be working on legal and policy matters in the patent system. We can't think of anyone better for a seat at the table in these critical times. No one has a better command of the history, the law, or where we need to take it to get back to a gold standard system. It's important to note, however, that views expressed on the Mossoff Minute are Adam's personal views and not necessarily those of the USPTO. And quite on topic for this month's installment, Adam is discussing an issue that could cause huge problems in Europe and for the global innovation economy more broadly.
Lots of developments are occurring internationally with respect to patents and our global innovation economy. The European Union very rightly and wisely decided to withdraw a proposed regulatory regime that would have imposed price controls and other types of restrictions on the licensing of patents on what we call standardized technologies like 5G and Wi-Fi and other types of core technologies, your USB ports and things like that. It was a very smart idea. It was really badly conceived. But unfortunately, then the United Kingdom stepped up a month later and said, we want to now consider imposing price controls on licensing of these standardized technologies and the patents on these standardized technologies. It seems that the idea of price controls is simply the bad idea that won't die. Price controls, historically and economically, everyone recognizes it destroys markets. It destroys the ability to create new innovations and new values that create flourishing human lives in society and drives economic growth. Hopefully, the UK will see the light in the same way that the European Union did and will also decide not to adopt this regulatory regime. Stay tuned.
Thanks, Adam. We're also publishing clips from the Mossoff Minute as short-form videos on Instagram Reels, YouTube Shorts, and TikTok. You can check out these shorts and follow us at Aurora Patents on all three platforms. And now, without further ado, take it away, Will.
Okay, so I'm going to talk about European patent process with a little bit of a history lesson to begin with.
Josh loved this when he saw this because Will takes it all the way back.
Yeah.
Gives us a good reflection.
So, the history of Europe is riddled with nationalism and war. There are dozens of countries in Europe, and the borders of those countries have changed drastically over the centuries. Once upon a time, there were kingdoms, dukedoms, principalities, even empires, and some of those still survive today. It's a fractured continent. But let me take you back a few centuries to the early days of the US. The Revolutionary War is finished, and the King of England has more pressing things to think about. There's one man in particular giving Europe the runaround, and that's Napoleon Bonaparte. The Napoleonic Wars were a bloody period in European history, but also one of profound change across the continent. So setting the stage, the year is 1804, and the Napoleonic Code has just been created. That's a civil code of laws for a democratic era, dissociated from the whims of the monarchy. By 1812, the French Empire of Napoleon spans across Europe from the Iberian Peninsula all the way down into Portugal, and then on the other side up to Russia. Whilst Napoleon's grand army is conquering everything in its path, the legal code, the Napoleonic Code, is spreading across the continent, and the whole of Europe, pretty much, finds itself with a unified legal system. Over time, all empires fall, and the French Empire was no different. But after the Napoleon's defeat at Waterloo, that code remained. Fast forward more than a century, and the Second World War has devastated Europe. Germany has been split in two by the Allied forces, and on the Soviet side, the Iron Curtain has come down. It's 1957, and the Cold War is in full swing. Old enmities are forgotten, and there's a desire for cooperation across Western Europe in particular. That point, the first European community is formed between West Germany, France, Italy, Belgium, the Netherlands, and Luxembourg. And thus, that's the start of the political and economic collaboration in earnest between European nations. That's made all the simpler by the consistent set of legal principles across those countries. Moving forwards, we're into 1973, and the European Patent Convention is signed. The purpose of IP systems is to reward R&D, and not forgetting patents are economic tools, so there's an interest in economically developed countries in Europe in that patent system. That European patent system, the European Patent Convention, is signed between West Germany, France, Belgium, Netherlands, Luxembourg, plus Switzerland and the UK. So therein, we've already got a bit of a split. There's a divergence between that political union that formed the European community and the economic collaboration of the European patent system. We've suddenly got Switzerland and the UK involved. And that goes a little bit of the way to explain some of the curiosities of the European patent system. We in the UK operate under a common law system, unlike the civil code that exists in continental Europe. So at the point of genesis of the European Patent Convention, UK, France, Germany arguing over the details of the actual rules and systems of the EPC, and there's a little bit of that UK common law bleed into the European system. Following on from that, we're in 1993, signing of the Maastricht Treaty. The European Union is formed. That extends that European community to UK, Ireland, Denmark, Greece, Spain, and Portugal. At that point, we're in end of history territory. Countries of Europe appear to be on convergent path towards unity and prosperity forevermore. That's the so-called ever closer union that is the European Union. And that's a phrase that came back to haunt us in 2016 when the UK pulled out of the European Union. Putting that to one side, we've got a European patent system formed. Politics and economics make uneasy bedfellows, but we've got the system and we've suddenly got the European Patent Office, formed in 1977. That's headquartered in Munich, and the EPO has the power to grant European patents across all of the contracting member states of the EPC. That European Patent Convention has grown with members over time. The current contracting member states are Albania, Austria, Belgium, Bulgaria, Croatia, Cyprus, Czech Republic, Denmark, Estonia, Finland, France, Germany, Greece, Hungary, Iceland, Ireland, Italy, Latvia, Liechtenstein, Lithuania, Luxembourg, Malta, Monaco, Montenegro, Netherlands, North Macedonia, Norway, Poland, Portugal, Romania, San Marino, Serbia, Slovakia, Slovenia, Spain, Sweden, Switzerland, Turkey, and the UK. And better men than me will have tried to reel those off without something in front of them.
I was going to ask if that's a drinking game.
Yeah, or I want a song, yeah.
Yeah, something like the Elements song. It would be good.
Yeah,
You'd be able to reel them off without actually having to look them up. There's also one extension state, and that's Bosnia and Herzegovina, and 6 validation states: Morocco, Moldova, Tunisia, Cambodia, Georgia, and Laos, which joined in April 25. So you'll note there that actually quite a lot of those countries aren't even in Europe. So the European patent covers up to 45 territories in total, which obviously is a lot in one go. And therefore, it's possible to get quite a lot of bang for your buck with a European application, provided the number of states you want to cover is all you're interested in. Now, I don't know about you, but some of those countries are probably a little bit more commercially important than others. And therefore, there's a desire to actually think about at the beginning of the process whether or not the European patent is the right way forwards. Because actually, maybe it's just a German patent. Fine. European Patent Convention covers all of those countries, but each individual state has its own patent laws. So it's possible to apply directly for patents in each individual country, and it's also possible to enforce them in each individual country. So there's a bit of a conceptual split between the European patent, which is a universal right, but also this European patent system, which actually really feeds into a lot of individual countries' national laws. Somewhat difficult concept to somewhat get your head around, particularly for non-Europeans, and it's often quite difficult for us as European patent attorneys to get our heads around the way the process works. But who's involved in the system? I've talked about the EPO, which is a huge non-governmental organization with vast numbers of technically qualified examiners, just like the USPTO. And they're responsible for the grant of European patents. Those examiners are highly technically qualified, but on top of that, they must also be multilingual, because those patents in Europe can be filed in any of English, French, or German, and there's no preference for any of those. So European examiners must themselves be fluent in at least 2 of those languages. So they're quite hard people to come by. Got to have the technical skills, got to have the linguistic skills as well. And certainly English patent examiners are few and far between at the EPO, because most of the English don't speak anything other than English. So you know, you're often dealing with French or German, Spanish, Italian examiners. On the other side, you've got people like me, European patent attorneys, who have taken the alternative route. We're registered to represent clients before not only the EPO, but our own national offices as well, which means we've got that twin view. We can see both how to get the European patents granted, but also how you then go through that local national enforcement process.
Will,
but primarily,
is that a double barring then? Kind of like in the, you know, like in the US to be barred in every state. So then is it like a separate exam for the UK and then a separate exam for EPO? Or is there some reciprocity?
That's right. So the UK system, you have exams that you take to qualify. I mean, I hesitate to call it barring, because we're somewhere between a patent attorney and a patent agent, in truth, in that we have limited rights of representation in court. We can only represent clients before specific IP courts, the IPEC in the UK, the High Court in the Patents Division. And the EPO have their own qualifying exams. There's a little bit of leeway given if you pass the European exams on drafting an amendment, you get a bye in the UK exams. But ultimately, you still have to take both routes if you want to have that dual qualification. Okay, so from there, we've got the people involved. But what's actually in a European patent? Well, I'm probably telling you guys to suck eggs, really, because it's very much the same sort of document that you have in a US patent. You've got description, you've got claims, you've got drawings. But there are crucial differences. And first and foremost is that point that I was making about individual national rights. The European patent application is a bundle. It is a bundle of national rights. And that means that although it's centrally examined, it can technically have different parts of the application in each individual state. So it is possible, say, depending on the prior art considerations that you come up across, to have, say, different claims in the European patent application in the UK and France, because there are potential prior individual rights in those countries that may be novelty destroying. So it's often referred to as that single patent application, but it's in many ways not. It is a collective, hopefully singular application that is examined and granted centrally, but assessed according to the national laws when it comes to infringement and validity later on. It's also unusual in the sense that you've got the choice of languages when you file the application. So we can pick English, we can pick German, we can pick French, and that language propagates through the application process. It becomes the official language of the application. Now, you've got to pick one of those 3 official languages. They're the official languages of the EPO. And Spanish and Italian speakers often feel quite hard done by there because they've missed out on the translation provisions. But for simplicity's sake, we've got the 3 languages. So that covers the language arrangements of quite a lot of those original countries that formed the EPC. The Luxembourg, the Switzerlands, they've got English and French and German in their national languages to start with. So you can see why they've decided on those 3 languages from the get-go. By the time the patent grants, claims of the European application must have been translated into all 3 languages. And at that point, suddenly you've got a multilingual document in front of you. So one of the biggest things that applicants and practitioners need to be aware of when it comes to Europe is translations play a massive part, absolutely huge part in the European patent system. And translation is naturally quite a subjective process. Languages don't necessarily map onto one another exactly. And with patents, that can obviously result in differences in scope in different countries if your translation has gone astray. So that leads to the scenario where European patent examiners have this very well documented and justified reputation for extreme linguistic strictness during the examination process. So they're going to be really hot on making sure that if you are making amendments, they are rigidly stuck to the wording that you used from the beginning, because otherwise you can propagate translation mistakes through. Now, I've touched on it slightly before. Each European country does have its own national patent office. And it is possible to file a patent application in each country individually. I think, Ashley, you touched on this in the previous podcast, that there are decisions to be made about whether or not you do go with the European process. But the main advantage of the European patent application is that you avoid the need to go through examination in the local language of that country. If you file an individual application in Poland, you're going to be filing a Polish specification. You're going to be dealing with a Polish language application. And there are considerations on the technical subject matter as well. So
Will, going back to that real quick. So is there not, so as an example, like with Germany, let's take Germany just for as, because a lot of times clients, when they do go through EPO, sometimes they maybe only validate in Germany because it tends to be more of the economic center, at least on that side of the pond. And so is there no, like if we had a client that wanted to file just in Germany directly, is there not an English recourse, or is the person that you're working with in Germany, for example, the whatever representation you have, are they going through some kind of translation process? Or anyways, yeah.
Yeah, I mean, the DPMA will expect your direct file German application to be in German. Some countries have kind of a dual system. So the Netherlands, technically you can file your application in English, provided you put your claims into Dutch. So they have that kind of split arrangement. But by and large, you're expecting to put your application into the local language. Germany needs to go to German. The only way to run through the...
Oh, go ahead. I was going to say, all communications are in German then?
Yes.
Okay.
Yes, so you'd expect then your correspondence with the German Patent Office direct to be in German. So the way, if you want to prosecute that in English, you can go through it through the EPO, which allows you to then run everything in English and then file your German claims translations at the end. So it's a bit odd that you might have a German patent application fully forced into German if you file it directly, but a European patent application, you might file in English, only then translate the claims into German, and then suddenly that's valid in Germany. It is the split between the two systems that creates that oddity, for want of a better word. You might have technical subject matter considerations as well. So if you've got flippantly a tea cozy, maybe you want to think about a UK patent only. You know, Europe drinks coffee. We don't. So I think from that side of things, there are serious considerations for applicants based on where their target markets are, because ultimately a European patent application is going to be more expensive once you get above one or two countries.
Hey, Will, that leads me
Yep.
to a question you and I ran into here this last month. So with Brexit and with the UK versus other validated countries in Europe, what do you recommend kind of for a tip or a trick if it really isn't dependent on the invention, like T-Cozy in the UK, but not Europe? If it really is something you want in both the UK and other European countries that you're going to validate in, do you suggest filing as an EPO application and then validating later in the UK? Or just walk me through that scenario for the team.
I mean, you're going to get a lot of hypotheticals based on which countries you're actually going to want to go into. You know, you'll as a patent applicant, you'll have an idea as to which countries are important. Hopefully, obviously, the EPO system gives you a lot of flexibility because the process is slow, and you don't need to make your decision on countries until we're possibly talking 5-6 years down the line. That obviously gives you a massive advantage over filing UK, Germany, France, either directly via the Paris Convention or as PCT national phases. Generally, I'd say to applicants, think about that. Flexibility is probably your biggest benefit, particularly if you've not got a technical reason to select countries. Obviously, there are cost implications to doing that, but they don't really manifest until quite a way down the line, and often applicants will decide to abandon applications. So your upfront costs with European versus multiple individual nations is probably going to be lower.
Okay, so at the end of your process, let's say you go PCT national stage, and now you have to validate. You would validate separately now in the UK and separately now in other European countries as well. Is there any problem or overlap or issue or like something where I have the same patent application in the same jurisdiction between the UK and like another European country, or that you only run into that if you have an EPO and a UK in parallel?
Exactly that. So
Okay.
from the purposes of differentiating between the applications, yes, the EPO patent is a bundle of national rights, but they're separate, so they're not conflicting in any way. So your German one doesn't interact with your British one. Yes, you might get them knocked out centrally via an opposition process, for example, but ultimately, if you're going to enforce them, they're going to be in different places. With filing an EPO national phase versus a UK national phase, well, suddenly you've got two patents that could both come into force in the UK. So you end up with effectively a double patenting type problem. And the EPO pretty much always takes precedence. So there is a strategic consideration there. If the local patent office see that you've got a European patent granted and a local patent applied for or in the process of granting, usually there'll be a forced revocation of the local one.
Got it.
Unless you can remove the double patenting issue.
Change
so
it
actually, you can almost do it. You can almost treat it like a process for a backdoor divisional, if you really want.
That's what I was thinking. Yeah, almost like
Yeah,
continuation. Like if you did like a system claim in the UK or something, and like a device or something in Europe or something, you know.
It certainly saves you the money on filing a divisional in Europe. if maybe one of your inventions is a little bit less crucial than the others.
Does that conflict, that potential like revocation, only come into play if you decide to extend grant in the UK from the European? Like, what if you had a UK patent that you're going and then you have a European patent that gets allowed, or I guess gets allowed, but then you don't extend the European grant in the UK? Can you stick with your original UK patent and not have the EPO patent like read on it?
No, so you've got to be really careful with that, actually, David. The crystallization of those rights in the country technically comes into force at the point of grant. The validation process at the end makes it enforceable, but the patent is already effectively granted in that country. So at that point, you've suddenly got UK and UK at the same time. The way to get around it is before the grant of the European patent, say if you want to maintain an existing UK right, you need to revoke the designation of the UK on the European patent so that it effectively becomes a Europe minus UK patent.
Yeah, okay.
It can be quite tricky to make that decision because certainly in the UK, the patent office make the decision based on whether or not the claims overlap sufficiently to raise a double patenting objection. But what does that mean? Well, if you've got a broad claim in Europe and a narrow claim in the UK, you might think you're okay. But if your broad claim in Europe has a dependent claim which then matches the scope of the British application, it's going to lead to that revocation problem.
Thanks. Interesting. Yeah.
Fine. Back onto process. I'm going to jump into this anyway on the European patent system. If we go back and imagine we've got a pending US utility application, we've secured a filing tape. What do you do next? Well, you make your priority claim with a direct filed European application, for instance. We're talking non-PCT at this stage. So at that point in the process, EPO want filing fee and search fee. So we're already getting some fees up front, but not all of them. That's perhaps a slight difference to the way the US system works, in that we've got this very discrete separation between the search and examination divisions at the EPO. You get a search report early on in the European patent process, and then much later on you get examination reports, whereas you might only just get straight office actions at the USPTO. The rationale is that it gives applicants time to decide whether or not they want to commit to those later examination fees. So it's an expensive process, that European application process. You can pull out before you pay the examination fees. Publication, 18 months from priority date, same as everywhere else. But that publication brings out the search report into the public domain. And that then triggers the next deadline, which is the deadline for payment of the examination fee. So within 6 months of that search report being published, EPO is going to want their examination fee. And that shuttles the application into the examining division. And that's the point at which the designation fee comes into being. Designation fees are a historic charge for the EPO because it is nominally the price of electing all the member states of the EPC into the application. Now, once upon a time, you had to individually pay for countries on a territory by territory basis. And that kind of links back into the point I was making about the retraction of designated states. You could, once upon a time, have just left countries out in order to avoid double patenting in local countries. But it was rare. So the EPO moved to the system where all countries all at once will have the full fee, thank you very much. And then you pull them back out if you don't want overlap. Fine. The EPO is a very good system for extracting fees from applicants. It's wealthy.
So, Will, is there a cost savings? I mean, just for argument's sake. So like most of our clients, I would argue, when they're considering validation, the key countries that come up routinely are, Germany, France, maybe sometimes Spain, maybe sometimes Italy, the Netherlands, UK. That's kind of it. So is there really any true cost savings to like undesignating all of those other countries? Are we talking about like a couple $100? We talking about, tens of dollars?
No, so
Like,
there's no saving whatsoever now.
oh, not even, okay.
That's the old system. The old system was country by country designation. Now it's
I
just the
got it,
one
yeah.
fee. You pull them out just to avoid the overlap.
Okay. Okay. So there is no, okay. Got you.
Yeah, they don't like giving money back. It's the truth.
That's a shared goal, I think, of most patent offices.
Well, I mean, the micro fees came in last year for European applications for SMEs and charities and universities, things like that. But it was noticeable that when the EPO did that, well, great, we're putting these 30% discounts on official fees, but suddenly we're going to jack up quite a lot of the fees by about 30%. So really, it just means that the large entities are paying quite a lot more now.
I have kind of a political question for you. So in the US, the US Patent Office is very fee-based and fee-run. And so they don't take, I don't know if they take any government like money to run and operate. Is the European Patent Office like that, or are they more like a government hand?
I can't answer that completely factually because I don't know
Okay.
the exact answer, but my understanding is that there's an amount of money that's paid obviously by official fees into the system, and I believe there is a cross exchange of funds from local patent offices because they have diverted some of their work to the EPO. So there's an element of governmental fees going in that direction.
Oh, interesting. Okay, thank you.
Peripherally sort of related question. In the US, examiners don't get a lot of time to examine each application, and they're on this whole quota system, and they, have all these incentives and need to move things through their desk.
Sure.
It seems like European examiners are given a lot more time to dig into all these nitty-gritty details and looking back at the specification and the exact language and a lot of stuff that the US examiners aren't differences in law, of course, but I'm curious if or if how that works for the European examiners. Do they have a similar kind of quota system or more time?
It's moving in that direction, certainly. They get allotted amounts of time to deal with specific actions, certainly discussions with examiners has alluded to that. There's a lot of political controversy within the EPO about the workers' rights and how much time they're allotted for things, how much expectation there is to increase productivity. And it all boils down to what is the point of the EPO? Is it a means for issuing patents, or is it a means for churning out as many work products as possible over a certain amount of time? And certainly the direction of travel has been in that latter direction recently. They pride themselves on high quality patents, but obviously if you reduce the amount of time that any examiner has to look at a case, it's going to reduce the quality of the patent. So they have these conflicting aims. There are a lot of user questionnaires that we get as attorneys and therefore users of the system as to, well, what do you actually expect out of the system? And it seems rare that the feedback is ever incorporated. Fees go up, examination timelines are designed to come down, but that's not necessarily always in the best interest of the applicant if they want the application to keep spinning along.
See, Will, you just didn't realize that, where those emails go in the surveys is just to a paper shredder on the other side,
I don't think they use any paper these days, to be honest, the EPO. It's just a great digital shredder. Fine. Where did we get to? We were on selection of individual states. Well, that doesn't happen anymore. But at some point in the process, you're paying an examination fee, you're paying a designation fee, off it goes to the examiners in the examination division. Fine. How soon is that going to come back? Well, not a very long time away. It might be that they've got targets for getting through actions, but the number of European patent applications is going up, so the queue is getting longer. So you're probably looking at years down the line that examination is going to occur unless you go through an acceleration process. So possibly the European patent applications just sat there in stasis for a very long time, and then suddenly it's maintenance fee time. Your renewal fees are paid year on year during pendency. So that can be quite a big shock to applicants who are used to, say, the post-grant renewal system that's in most other countries around the world. Obviously, there's a few exceptions around, but certainly the USPTO pays them after grant. Most of the Far Eastern countries pay their renewal fees after grant. And those renewal fees aren't small because they are tagged to a nominal percentage that tracks the kind of number of countries that are validated in. So they're kind of pegged to what you'd expect to pay if you were paying 4 or 5 countries worth of renewal fees locally. So they go up and up and up and up pretty quickly. And some countries have quite big jumps later on in their renewal system. Certainly after the 10th year in the UK, we get big jumps, and the EPO is no different. That's an interesting point. It comes back to Kristen's point from earlier. Actually, there is an element of the fees going backwards to the national offices as well, based on the renewal fees, because the national offices are missing out on their renewal fees based on the slow process of the EPO. So there is a bit of back and forth when it comes to fees going in and out of the EPO. Let's say we're through the process though. Examinations happened, we get a notice of intent to grant. Applicant then needs to confirm that their text is all to their satisfaction, and we've got more fees to pay. Grant and publishing fees need to be paid. We've then got to do translation of the claims into the other 2 languages that we didn't pick when we filed the application. So that's the first translation step. And we're going to see from here on in that we get translation after translation in the grant process, which can be a little bit surprising. Once we've met the requirements of paying the grant and publishing fees, great, we get a granted patent. And so we're on to validation. We've got the bundle of national rights, but we need to meet the individual requirements of the national offices. So UK IPO, happy with the English language pattern that we've got in place, or the French language pattern with English claims, all good and well. Italy, no, they're going to want to see everything in Italian. So we've got individual national requirements put in place on top of the European grant. Before that, though, we've got the first validation deadline in effect, and that's the unitary patent deadline. 1 month from grant, we need to decide whether or not we're going to file a unitary patent. So that's a relatively recent addition to the European patent process. It's 2023 and onwards, but it is the closest thing we've got to a formal EU patent, because it covers a relatively broad but not complete subset of EU countries in one go. And what we need to do for the unitary patent is file a unitary patent request, say we want this to come into force, and file a translation again. So this now is a translation into one of the other EU languages that's available. Not a specific EU language, mind. This is actually a bit of a cheat on the part of the EPO, because there isn't any legal effect to the translation for the unitary patent. It's very much there to provide training data for their translation programs. So probably at some point, the requirement to translate the entire unitary patent on grant will disappear, and there will be an EPO created machine translation system that will hopefully get better and better over time. Whether that will work in practice is going to be interesting, because what we see is that the translations that get put in place for the unitary patent request are the cheap ones. So we see a lot of Spanish go in, and we see quite a lot of German, just because we're already doing the claims, a little bit of French, maybe some Polish for people that are validating in Poland anyway, but not a lot beyond that. So I'm not not entirely clear how the EPO are going to be training their systems on all the other languages that they're proposing to translate into. I don't think we see many Latvian translations, for instance.
So from a process perspective, if you decide you want that unitary patent, you you can just say so, fill out the paperwork and the translation and do that. But if you previously opted out, I think we're going to have a few years of things where we had cases where we opted out of that system. Do you have to
Yeah.
revoke that and then you can also get the unitary patent?
The opt-out is automatically revoked when the unitary patent request goes in,
Oh,
because it's
okay.
it's non-compliant with the existence of the unitary patent.
Okay.
So unitary patent must be opted into the Unified Patent Court. So the Unified Patent Court is the central court of jurisdiction for the unitary patent, plus validated states which are members of the unitary patent, even if you're not using a unitary patent, unless opted out. So the purpose of the opt-out is to take, say, a German validation outside of the scope of the Unified Patents Court's jurisdiction.
And can you opt out anymore, or is that date gone?
It's still viable. It's just we see a lot of people making unitary patent requests because it's cost effective.
Sure.
And to be honest, the people that are fighting in the Unified Patent Court are big entities. It's expensive to litigate there. So for SMEs, for even medium to large businesses, probably the cost of the cost saving that you get from the unitary patent is too much of a win versus the risk of being in the Unified Patent Court, even though it's a relatively untested system. So we're seeing fewer and fewer opt-out requests over time. People are just happy to sit in the system and hope that the Googles of the world don't come down on them.
Well, it seemed like, this is a few years back now, but when, I can't remember if you provided these data or if we kind of just put this together, but it seemed to me that if you weren't going to validate in 4 or more countries, that the UPC was more expensive. If you were just going to validate in fewer than 4 countries, it was cheaper to do individual validation. You still have the enforcement issues, right? There's no unified court for enforcement, but if you're more concerned about front end costs, is that still hold true? Is that like rough metric?
Yeah, there's a couple of factors when it comes to the cost of the unitary patent. One is, well, you've got to put a translation in place. So the balance of the fee for validation slightly depends on whether the countries that you want to validate in are translation heavy countries. So at the point of validation, possibly an Italian translation is going to cost you the same as filing a unitary patent request. So at that point, it's a one or nothing. Great, you've already made your saving by doing unitary patent by getting Italy in the bargain. If you're looking at things like Germany, France, Netherlands, and let's say who else is the system that's not too complicated? Belgium, maybe. Those 4, well, you don't have to do a lot of translating in those countries because they're all broadly speaking permissive when it comes to the amount of translation you have to submit. Dutch only need the Dutch claims. Germany, France, Belgium, they're London Agreement countries, so they don't need the additional translation requirements. So really, you're not paying a lot for translation there. That's maybe the tipping point, because beyond that, you start adding extra countries in on a validation level. Maybe you're paying less, but your renewal fees will start to go up and up and up. Because the unitary patent renewal fees are set as a cumulative amount of what is it? It's UK, France, Germany, Italy, as was in 20 something or other, whenever they came up with the official fees. So the renewal fees are based on out-of-date renewal fees for starts, but it's set on 4 countries. So your unitary patent renewal fees will be lower than, say, 5 countries worth of renewal fees once you start paying them direct to the national offices. So that balance point is probably never going to change there. The one thing you can't do is say, oh, well, I've done Germany, France, Netherlands, Switzerland, Bulgaria in a classical validation mode. Maybe I say, well, I made a mistake with Bulgaria, I'll just drop it. Well, if you've gone via the unitary route, you can't just throw out a country. It's the one right. So you're committed to paying that 4's worth of renewal fees forevermore, or you lose the unitary patent. So it's a slightly longer term view if we look at it like that, because we've got to project how soon are we maybe going to kill parts of the patent if we were just left to our own devices and choosing country by country.
Yeah.
It's tricky. There's probably no hard and fast answer. I'd say it's probably relatively rare for somebody ticking along with a patent portfolio to start saying, oh, I'll chip away and drop these rights. It's from a mental load perspective, it's a lot easier to just say renew them all or don't renew them. Sure. I think maybe I over egg that point a little bit to clients, really, as being a bit of a fear factor.
No, it's good. It's a good point. Go ahead, Dave.
Yeah, one thing, and I'm curious to get your perspective on this, Will. One question that we get, and we also ask clients to think about when they're deciding where to extend grant, is if there was ever an issue of infringement or enforcement, would you spend the money to litigate an infringement in Belgium or in one of these small jurisdictions? And especially what you were just saying is interesting about the unitary court system being so expensive. If that's where your infringement is, sure, the unitary patent covers Belgium, but would you ever spend the money to litigate that? And as opposed to, well, if it's Germany, yes, or if it's Great Britain, I know that's outside of the unitary system, but a lot of our clients think about markets and competitors, of course, but where might the infringement or problem happen, and would we spend the money ever to try to enforce there? What's your perspective on that? Does that change your recommendation for whether someone would spend the extra money to go with a unitary patent versus just extending grant in Germany and Great Britain outside of the unitary patent anyway? Unitary patent plus Great Britain or Germany plus Great Britain? You know what I mean?
It's an excellent point. What's the purpose of a Belgian patent is what it boils down to, I suppose. Well, if you're going to litigate, you're probably going to start somewhere, aren't you? So you're going to forum shop. And if you win, let's say you get an injunction in Germany, probably you're going to encourage action against the infringer based on the Belgian market. And if you've already got the judgment in Germany or in the UK or in whichever is the prime market, you're probably going to have a much more receptive target, I would say. You're probably never realistically going to litigate in one of the smaller jurisdictions, but that's not the point. The point is that you're probably going to try and get the early judgment in the big one in order to make the infringer roll over everywhere else, because they know that you could do it. Whether you and obviously if they've lost, then they've got a big problem in recoverable costs from you bringing an action in another jurisdiction where it's just going to be legal fees thrown down the drain. So it still comes back to the kind of key and core point is, where is the recoverable amount going to be relevant? So if the Belgian market is worthless, don't validate in Belgium. If it's an incredibly valuable market, do it. Don't litigate there. Stick your oar in the UK or in Germany or France if you're so inclined. But stick to the big patent courts that have got extensive experience and good processes in order to apply consistent logic in the other ones. That's usually what I'd say. And certainly from a UK practitioner's perspective, I'd always say forum shop to the UK first, because we've got lots of relatively cheap and cheerful processes for getting decent opinions. We've got patent office opinions on infringement and validity that we can apply for that cost peanuts, frankly. They're non-binding, but obviously it's persuasive to a court if the patent office has already said, well, these guys infringe. You know, you can get that for four-figure sums, which you couldn't take a court action for that amount. So it's all about playing games and trying to encourage infringers to settle based on your most suitable jurisdiction.
Thanks. Yeah, no, that makes a lot of sense. Whenever we're talking about international protection, you can't file in every country around the world, of course. So usually, I guess, unless you're like your IBM or something. But like if what we're mainly often trying to do is have the conversation of where are the big markets so that you can block someone from making it worth their while to compete against you, etc. And that, from that perspective, the unitary patent could have a ton of value because it does let you file in all those countries around the world, or not really, around Europe, and cover everything, which is really not an option when you're thinking about most other places, even if you're not going to litigate there, to your point. So that's interesting. Yeah.
Yeah, I mean, that's the rub. You go for the unitary patent, you get that broad scope of protection, but you've lost the right to go through one of the German courts, which are quite reasonable when it comes to throwing out injunctions. Yeah. So that is the flip side. That's why you'd opt out, frankly, if you wanted to make use of a nullity action in Germany, for instance. Obviously, if you've got the unitary patent plus a UK one, you can always start your process in the UK, which is, sneaky. You certainly don't want to pay UPC court fees if you can avoid it as a small entity. Fine. We've talked about direct route. What's next on the agenda? Probably just to have a quick comparison to the Euro PCT process. So Euro PCT, you're not filing direct via the Paris Convention. You're filing a national phase at 31 months, probably. Sometimes we refer to it as the regional phase, just for semantic fun. But because we've missed a lot of those deadlines I talked about before in terms of search fee, filing fee, examination fee deadlines, we've got to pay them all up front. So EPO at that point gets a relatively expensive rep because suddenly lots of fees that were otherwise spread out over a long period of time all get clustered together. That said, if you've got the option to shop for your preferred ISA, if you choose the EPO in your PCT, suddenly that search fee gets waived. So you've probably knocked off a third of those official fees off in one go because you've already paid it effectively. So that if you know the client is keen on the EPO, not only can it speed up the process using the EPO as the ISA, but it can also make it cheaper for them downstream. Otherwise, you get voluntary amendment opportunities within 6 months or so of entering the national phase. So that can give you a little bit of flexibility to address problems in the international search report. But otherwise, from there, great, you're into the same process that I was discussing on the Paris Convention route. So going back to fees, obviously I've talked about the EPO being expensive. Particular things to think about, well, we've got claims fees. We've got claims fees in excess of 15 and punitive claims fees in excess of 50. So really, if drafting, I guess you kind of want to have that in the back of your mind. Obviously, it's not that dissimilar to having 20 free claims as in the US PTO, but that ramp up to everything above 50, you're looking at tens of thousands of euros for claims fees once you go up beyond that. So there is value in making sure that you've got a sensible set of options for the applicant early on that you can easily go, well, look, these are the EPO claims. I've knocked out a lot of the cruft. The other thing to think about is tech-heavy jurisdiction, tech-heavy fields, data-heavy fields can be punished quite severely for having lots of pages. So PCT applications which are run to hundreds of pages can get quite severely punished on page count. So if you can be concise in a PCT application, I know it's not possible sometimes for support for your actual filing, but you might want to keep the page count down to avoid those excess page fees. The other thing that we don't have in Europe is fees for having multiple independent claims. So there's no bar cost-wise to having multiple independent claims, but the risk that you run with different independent claims in an EPO application is that the EPO examiner says this is not a concise application, or this is plural subject matter, and that's it. They just won't search those multiple independent claims. So running quite a lot of independent claims when you contract down to 15, maybe at national phase entry, runs the risk of you only getting one claim search potentially. So there is a strategic consideration there to make sure that doesn't apply. Fine. Let's talk a little bit about some substantive points of EPO process. The processes between the EPO and the USPTO are not all that different. You've got certain patentability exclusions, schemes, rules, methods for performing a mental act, presentations of information. Abstract matter rejections do exist at the EPO, and they're pretty similar to what you'd expect at the USPTO. What's quite interesting is there are limitations at the EPO around methods of treatment and diagnosis of the human or animal body. So there can run into difficulties with granting of medical method claims. Patents can be granted to therapeutic or diagnostic products if they're novel and inventive, or if their medical use is. So you can't have the old Swiss type of claim at the EPO, your use of product X in the treatment of disease Y, but you can construct a claim which is the flip of that. So product X for use in the treatment of disease Y, that's an okay claim structure. So it's quite useful to think about building claims with maybe European requirements in mind if you're doing medical type applications, because otherwise you'll probably just get pointless clarity objections from a European examiner downstream. They'll just tell you reverse this in order to have it searched. Those new medical uses, they can cover new dosage regimes, new modes of administration of drugs, or even new patient groupings that the medical treatment is applicable to. So it's permissive, provided you've structured your claims correctly.
Can you say that again? Product X for use
So
in...
the valid EPO construction for a second medical use is product X for use in the treatment of disease Y. So it's got to be a product claim ultimately, but the novelty, the inventiveness can be granted by the use. So you'd enforce on, well, the sale of the drug for the particular purpose, rather than the administration of it. Think about novelty. That follows on from, as the next step from excluded matter. There's not masses of differences to USPTO practice, but you do need to think about the absence of an inventor grace period in Europe. I think, again, that's something that Ashley touched on in the international podcast, but you can't use the US grace period provisions in Europe. There's an absolute novelty bar for disclosures that beat the priority date. There's also what we have are novelty-only citations, which are filed before but published after documents which are either European or Euro PCT applications. So EP or WO documents that have subsequently gone into European phase, they can be cited against the novelty of claims, but not inventive step. So that puts them in a slightly odd category. Effectively, the EPO is saying that, well, we don't want two patents granted for the same thing, but we can't have expected an inventor to have known about something for obviousness before it was published, which is somewhat reasonable, but it's quite a cumbersome mechanism to look at prior art that way. What's sometimes taken for granted at the EPO is that once a European examiner finds a defect in a claim on novelty grounds, they often won't then move on to inventive step. They'll just say, well, claim's non-compliant with the EPC. So it does feel sometimes like the deck is stacked against the applicant. You've kind of got to preempt the inventive step attack when you respond. You're expected to respond on inventive step grounds, even if the objection's not there, because it's subsidiary to novelty. So that then feeds into, well, how do you do that? Luckily, I say luckily, but the rigid structure of the EPO's problem solution approach to the assessment of inventive step does kind of tease you along. So the identification of the novel features of the claim will help identify what you're going to use in your inventive step argument at the EPO. What we do is we find the closest single prior art document, acting as the most likely starting point for the skilled person to arrive at the claimed invention. The differences between that document and the claimed invention are determined. And those differences are what you'd expect to have argued on novelty. It's then the purpose of those differences within the whole invention that allows for the formulation of an objective technical problem to be identified. And once you've identified that objective technical problem, you work out whether the skilled problem has deemed the skilled person would have deemed the solution obvious. And that's how the two-part structure of a European claim appears, the characterized by or characterized in that structure. It's the EPO asking you to split between the stuff known in the prior art and the stuff that's not, and then you're explaining why the characterizing portion is inventive in its own right. That might look like it's something that benefits third parties more than the patentee, frankly, when you read a claim, and that may well be true. Why they do that? Well, I think it's a lot to do with everything being strict at the EPO. There's a rigid set of rules to follow, and they're trying to balance that third-party rights versus patentee rights all in one go, so that it's easy to enforce when, and it comes back to, you're possibly doing it in lots of different languages. So it allows for kind of simplified access to the inventiveness points that you're arguing on during litigation. What's interesting about that objective technical problem construction is that at the EPO, if you haven't put something in your application, in the description, to explain what the objective technical problem is, you run the risk of the European examiner just deciding it for you. So there's a lot of what we do is making sure that there are sufficient advantages just littered through the description to make sure that you can point back, well, this is actually my objective technical problem. It was there all along. The absence of that can give you a lot of problems during European examination. Let's say the EPO has found prior art relative to all the claims. You've found the core inventive difference to make your problem solution attack work, hidden away in the detailed description. Suddenly we're at the point of EPO added matter problems. EPO applies a test that's modestly called the gold standard, where amendments can only be made within the limits of what a skilled person would directly and unambiguously derive from the disclosure. And the disclosure is deemed to be description, claims, drawings, but not abstract, which is something that people can fall foul of quite a lot. Abstract's not deemed relevant for amendments. What EPO examiners are quite fond of saying is that the description is not a reservoir of information from which features can be cherry-picked. That comes up all the time. But in practical terms, it means that if unless there's a specific pointer in the description stating that a certain feature is applicable to, in general terms, to all embodiments, a European examiner is probably going to deem that feature to be embodiment specific. And then if you try and make an amendment on that feature, all of the other features of the embodiment are probably going to be forced to be absorbed into the claims. That's really difficult to anticipate when drafting. Short, snappy sentences are probably the way to go, so that you kind of separate out individual features rather than have long linked sentences. That does at least keep European examiners at bay. Intermediate generalization. That's something that European examiners are really big on, which is broadly the attempt to secure claim protection, which is between an original broad statement in the disclosure and an embodiment-specific disclosure. So what it helps to have is hierarchical funneling of features of claim integers baked into the description. If I were to broadly claim a vehicle in a claim, and then my only example in the description is Tesla Model 3, I'm going to find it difficult to generalize to a car even, or an EV, because that wording isn't in the description somewhere. So having those intermediate positions littered in place does give you mechanisms to get around the hideous intermediate generalization problem that EPO examiners will inevitably throw. Fine, I'll jump through the grant process section because we've talked a lot about unitary patents already. In fact, we've talked about UPC enforcement a lot. But in terms of the UPC, enforcement needs to be either in the national court or at the UPC. You need to make strategic decisions early on as to whether or not you really want that to happen. So at the point of validation, that's where the discussion with the client needs to be had. Am I going to classically validate, as in pick individual countries and ignore the unitary patent in order to select that opt-out process to avoid the jurisdiction of the Unified Patent Court, UPC? Or am I going to accept that I want the unitary patent and all the advantages cost-wise that brings me, and accept that that court could centrally revoke the entire unitary patent in one go? That's the discussion to be had with clients early on. For countries outside the UPC, well, litigation is unchanged. UK patents litigated in UK courts, so are UK parts of European patents. Same for Spanish validations, Czech validations, so on and so forth. Any of the non-18 countries that form part of the unitary patent system. Why aren't all the EU countries in the UPC is a pretty common question. Well, EU countries, they're the only ones that are permitted to be in, so UK, Switzerland can't be in at all. Spain kept out on linguistic grounds. They're pretty unhappy that the UPC mandated that process had to be conducted in French, German, or English, same as the EPO. Some countries had objections on commercial grounds that the UPC was not very valuable to their internal patent system. That was the reason the Czech Republic gave to stay out. So there's lots of sort of bitty squabbling within Europe over whether they should actually form this true EU patent. Something has come along. Something is there in terms of a unitary patent, but it's not been fully and wholly accepted. So we've still got this bipartite system. And to circle back entirely, that's the history of Europe in a nutshell. You get economic and political collaboration, but there's bickering, there's fighting over the details. But ultimately, the first European patent was filed 1978. So something's been going right over the past 40 years. Europeans can work together. Overall, what are some useful points for practitioners to take away? Well, one, EPO is expensive, but equally it can be quite good value at the same time, certainly in terms of those upfront costs for clients. But applicants do need to think about whether or not jumping into the system is sensible. They need to have a think about whether actually just UK, Germany, France perhaps is all they really need, and whether that's actually the more cost-effective thing to do. Having a good understanding of what you're going to get into in terms of validation early on in the process is actually quite important for making those decisions. So there is a lot of value in looking forwards to the very end of the process to work out whether or not you're going to go down the direct file route or the unitary pattern route, or even the European pattern route at all. In terms of practical points during examination, probably the thing that US practitioners most have issues with is that added matter point. Intermediate generalization is an awful thing to get stuck on when you've got something that's clever. So trying to make sure that at the drafting stage, you've got plenty of terms that you can rely on to avoid later problems on an added matter front is probably the best advice I can give to any USPTO agent or attorney. Equally, on that technical problem to be solved side of things for inventive step, well, the more advantageous features that are listed in the application, the more likely it is you're going to get through a problem solution attack on your pattern. So putting those features in from the get-go, great, even if they only go in at PCT stage. But also just be careful with the claims, because there are lots of traps you can fall into on punitive costs for starts in terms of the claims fees themselves, but also putting in claims that aren't compliant with the eligibility rules. So we're talking about maybe those medical method type claims, putting them in Swiss format, but also putting in those multiple independent claims and making sure that you're not putting claims in that are just not going to get searched at all. This is a waste of time. So there's some summary points there. Hopefully that's a bit of a whistle-stop tour through EPO process.
No, it was really good. Thank you. I will say this, from work product that you see coming out of us, please do let us know if something is a big no-no or if, hey, you don't want to do this.
Good. Well, I mean, the more we can make it streamlined, the better, because the less likely it is you're going to get into trouble with those, extended renewal fees, because you're speeding up the process if it's smooth. The less likely it is that you're going to get into, potential difficulties with scope. I mean, it all comes back to that added matter point. Added matter is just the worst of the objections that you can get in Europe. Save for sufficiency objections, we touch wood, we don't get too many of those unless someone's let the AI run loose on the draft in the first instance.
So internally, we don't tend to have a huge problem utilizing AI kind of appropriately, but we have a lot of clients who really want to get involved. And hey, I threw this in AI, and even if it's sandboxed AI where it's kind of protected and not out in the world, the things that it spits out that aren't vetted by the inventors is crazy. And the things that are coming in, it is. And I'm given 30-page documents to read about something they think should be in their application, and I'm like, I don't even think any of this should be in there. Like, where did this come from? Yeah, it's crazy.
Yeah, certainly I get a lot of clients sending me patent applications that are ready for review, which are claims that are barely in English and detailed description which is just randomly generated, and it's difficult. It's difficult to say that actually this is going to give you sufficiency problems. No matter where you go. It's an increasing problem, and I don't know whether the professional AI drafting tools are going to solve this completely. It's a tool at the end of the day, isn't it? It still requires some sort of advisory input as to whether or not it's doing the right thing.
Yeah. Absolutely. So I don't know when her article is due, but Ashley is working on an article for a US company called think Thompson Innovation, and she's vetting a handful of drafting AI tools. And so she's going to do a comparison across them. So if we can get you a copy of that, we will
Oh, that's
pass
exciting.
that along. It sounded interesting. I think it's taking her a little more effort than she expected, but it's kind of a cool pet project. So we'll let you know.
Good stuff.
Yeah, thanks,
Yeah.
Will. It was really informative. It's so complicated, the European landscape. So thank you for helping us navigate it.
I tell you what, I was slightly panicked at one point that I was sort of scrolling through my prepared bits and pieces, and my page count tracker got stuck. So I thought, as we were getting towards like 6:30, 6:45 here, suddenly, I'm only halfway through this whole thing, saying I'm on page 5 of 11. What's happening? I'm going to be speaking till it's midnight here. It ran to pretty much the time I was expecting in the end. Good. Right, I'm going to sign off there then, and actually sort of go and find my tea, I think.
Sounds perfect.
Yeah, good stuff. But good to see you all, and catch you again soon.
Thank you. You
Thanks.
as well.
Yeah,
Thank you, Will.
too.
Bye, guys.
All right, that's all for today, folks. Thanks for listening, and remember to check us out at aurorapatents.com for more great podcasts, blogs, and videos covering all things patent strategy. And if you're an agent or attorney and would like to be part of the discussion, or an inventor with a topic you'd like to hear discussed, email us at podcast@aurorapatents.com. Do remember that this podcast does not constitute legal advice, and until next time, keep calm and patent on.